5 seconds to go. Start. On the other hand, Shri Tarun Verma, the learned counsel for the Oriental Bank of Commerce, submitted that the petitioners have an efficacious remedy of filing an application under Section 17(1) of the Act before the Debts Recovery Tribunal. In support of his submission, the learned counsel has placed reliance upon a decision of the Supreme Court in United Bank of India versus Satyavati Tandon and others 2010 8 SCC 110. It was urged that after the declaration of the account of the borrower as NPA, the bank has already filed a suit before the tribunal for recovery of its amount, and that the tribunal has also issued an interim order restraining the borrower from alienating the properties, including the properties which is sought to be released through the present writ petition. The learned counsel contended that the appropriate remedy for the petitioner is to move an appropriate application before the Debts Recovery Tribunal, which would be considered, and appropriate orders would be passed by the tribunal. The learned counsel contended that consequently it was not a fit case for the writ court to entertain such petitions. The learned counsel submitted that the concurrence given by the Oriental Bank of Commerce for release of the property of petitioner number 1 was subject to fulfillment of certain terms and conditions at the time when the account of the borrower was standard and regular, but during the consideration of the matter, the borrower did not maintain financial discipline and the account of the borrower became NPA. As such, in the changed circumstances, the bank was not bound to honor the concurrence since the conditions were not fulfilled by the petitioners. The learned counsel submitted that the borrower has failed to maintain the financial discipline and have made no effort to regularize the account, and consequently, the request for substitution of the mortgaged properties could not be acceded to. The learned counsel further submitted that the account of the borrower was declared NPA as per the Reserve Bank of India guidelines, and since the borrower did not make any effort to regularize its accounts, proceedings under the Act was initiated. The learned counsel contended that a valid notice under Section 13(2) of the Act has been issued, and the objection of the borrowers and other guarantors were considered and rejected under Section 13(3)(a) of the Act, and only thereafter a notice under Section 13(4) of the Act was issued, and now an application for recovery of the amount has been filed under Section 19 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993. The learned counsel submitted that the plea of the petitioners that the respondent's bank had wrongly declared the account of the borrower as NPA is misconceived, inasmuch as such plea could not be raised for the first time in a writ jurisdiction, as the said plea was never raised before the bank, nor was raised in their objection filed under Section 13(3)(a) of the Act. Stop.